you hear me?
There you go. Now I can hear you. Please raise your right hand. You swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
You may put your hand down and please listen carefully to the questions. And Mr. Gwynn, for the state, you may proceed, sir.
Yes, Judge. Trooper, can you state your full name for the record?
Isaiah Joseph Diaz,
Okay. What police department do you currently serve with?
the Texas Department of Public Safety.
Okay. How long have you been with the Texas Department of Public Safety?
5 years, sir.
Okay. Okay. I'd like to draw your attention to the night of November 2nd, 2019.
One moment, state. Just one moment. I'm sorry to interrupt. We don't need the jail anymore. We're through with jail. Jill, we're through with you. Thank you so much. Your excuse, okay?
Thank you, Your Honor. Thank you.
Yeah, yes, sir. Bye-bye.
Oh.
And I'm sorry, Miss State. You may proceed now.
Trooper, I'd like to draw your attention to the night of November 2nd, 2019. Where were you patrolling that night?
I was on State Highway 107, going westbound towards FM 493.
Okay. What city was this in?
Elsa,
Okay. What county is this in?
Hidalgo,
And what state was this in?
Texas, sir.
Okay. And while you were patrolling, did you observe anything out of ordinary?
I did. I observed a silver and colored vehicle at a traffic light. It grabbed my attention first by failed to stop at a designated point, but that just grabbed my attention. Then the vehicle proceeded to turn southbound, and in doing so, it did so in kind of a wide left turn, which again grabbed my attention, but just my attention. I decided not to do a traffic stop just to further observe the vehicle. And then that's when the vehicle traveling southbound on 493 failed to drive in a single lane, and that's when I decided to conduct a traffic stop.
And what type of car was this?
I believe it was a Chevy Equinox.
Okay. Was this a motor vehicle?
Yes, sir.
And did you conduct a stop on the vehicle?
I did, sir.
Did the driver stop right away?
He proceeded to stop at the improved shoulder.
And did you make contact with the driver?
Yes, sir.
Do you see the driver on Zoom with us here today?
Give me a second. Yes, he's a gentleman wearing the facial mask.
Okay. Your Honor, may the record reflect that the witness has identified the defendant?
Okay.
Now, once you make contact with the defendant, did you make any observation of the defendant?
I did. First, I observed his eyes being a glassy color and a strong odor of alcohol emitting from his breath and inside the vehicle.
Okay. Did you ask the defendant if he been drinking?
I did.
And what did he say?
He said he consumed two beers at that time when he was still inside the vehicle.
Okay. What did he say he consumed the alcohol?
Well, first I asked him to get out of the vehicle, and then I asked him again to further explain. And that's when he said he drank two 24-ounce Modelos starting from 4 p.m.
Okay. And okay, did you ask the defendant to perform the standardized field sobriety test?
I did, sir. Yes.
Okay. And are you certified to perform the standardized field sobriety test?
I am, sir.
Okay. And did the defendant indicate any medical condition that would prevent him from performing the test?
Starting with the first test with the horizontal gaze nystagmus, he displayed unequal tracking, which eliminates him from being a participant of the test. So I could not further conduct that test on him.
So did the defendant attempt the test?
He proceeded with my instructions until I examined to see if he qualified, and that's when I determined that he did not qualify for the horizontal gaze nystagmus test. So I proceeded on with the next two tests.
Okay.
When asking about the next test, which would be the walk and turn, he stated that he had a sprained ankle on his right leg. So because the test requires him to proceed with walking and some type of physical activity, I decided not to administer the walk and turn test.
Okay. So it was the walk and turn test that he indicated he was injured?
Yeah, it was walk and turn where he explained that he had a sprained ankle.
Okay. So what was the next test that you asked the defendant to perform?
The next was a one leg stand, which the suspect at the time can choose which leg to stand on. Being that his right ankle was the one that was sprained, he was more than capable to stand on his left leg. So we proceeded with that test, and I had to terminate that test for the safety of Mr. Rodriguez, because if you watch the video, you'll see that he almost falls into the grass because he can't keep his balance.
Okay. But were the tests performed though?
It was performed, but I saw two clues before I terminated the test, which was swaying and put foot down.
Okay. Were instructions given to the defendant on how to perform the test?
Yes, sir. Both verbally and physically demonstrated it.
Okay. And did the defendant indicate that he understood the instruction?
He did.
Trooper, if I may ask, on the horizontal stigma test, why is the inability to equally tracking the pen disqualify him from performing the test?
We need the eyes to be equal tracking so that we can see specific clues when administering that test. And when both the eyes aren't equally tracking, there's no way to determine if he has the clues on the HDN.
Okay. And for the walk and turn, why does the defendant having an ankle injury would disqualify him from performing that test?
So it requires 9 heel-to-toe steps in a straight line, which would mean that he would have to put pressure on that right ankle, and it would just further escalate the injury if there is one.
For the one leg stand test, Trooper, for the two clues that you observed, were those signs of intoxication?
Yes, sir.
So, Trooper, with your years with your training and experience, and after observing the defendant, talking to the defendant, did you form an opinion whether the defendant was under influence of alcohol to the extent that he had normal use of his mental or physical faculties?
Yes, sir.
Okay. And what was your opinion based off?
It was based off the evidence that I observed while he was still in the vehicle, which was the glassy eyes, the odor of alcohol, and his slurred speech, which he had, and then the SFSTs, which mostly the one leg stand where he couldn't even perform it because he was falling off balance so bad.
Okay. And once you determined that he was intoxicated, what did you do next?
I told him he was being placed under arrest for driving while intoxicated.
Okay, and did you were Miranda rights given to the defendant?
Yes, from while we're inside my patrol unit.
And Your Honor, we would object to any further questioning as an arrest has already been made. We are suppressing the reasonable suspicion for the stop and the probable cause for the arrest, Your Honor.
All right.
We believe that any testimony after. Oh, thank you, Your Honor. Thank you.
Sustain.
Judges, the state passes the witness.
All right, Mr. Ortegon.
Trooper, how you doing, sir? My name is Jorge Ortegon. I'm a defense attorney. I represent Mr. Rodriguez. I'm going to ask you a series of questions, and if you need me to rephrase any of them, or if you can't understand me, feel free to let me know, and I'll happily rephrase for you, okay?
Yes, sir.
And can you hear me pretty clearly right now?
Right now, yes, sir.
Okay. Now, Trooper, this arrest occurred on November 2nd, 2019. Is that correct?
I believe so, yes, sir.
Okay, and you've indicated that you've been an officer today for 5 years. Is that correct?
Yes, sir.
So how long would you have been an officer or a trooper at the time of this arrest?
About around 3.5.
3.5 years. Okay, now, have you had an opportunity to review your report before this hearing?
Yes, sir.
Okay, and have you made arrests since this hearing? DWI arrest since the arrest of my client?
Yes, sir.
Would you agree with me if I stated that your ability to review the police report helps you recall or better recollect the facts that happened on the date my client was arrested?
Yes, sir, since it was 3 years ago.
Okay. So basically, your testimony today is largely based off of the report you created. Is that correct?
Not just the report, but also the video, sir.
Okay. Now, as for the work, you make any changes? Is there any changes you would like to make at this point, if you could, regarding your police report?
No, sir.
Is there anything you would like to add to this police report?
No, sir.
Okay. So you indicated that my client failed to drive in a single lane multiple times. Is that correct?
Yes, sir. That was the reason for the stop.
Okay. At any point, did my client almost cause an accident?
No, sir.
At any point, was he a danger to other vehicles on the roadway?
I don't believe there at that time, no, sir.
Okay. You also indicated that your initial communication with my client was that had noticed that he had slurred speech, glassy eyes, and a strong odor of alcohol emitting from his breath. Is that correct?
Yes, sir.
Have you spoken to my client before that date?
No, sir.
So this is your first communication with my client. Is that correct?
Yes, sir.
Will you elaborate on the alleged slurred speech that my client had?
It is as if he had a thick tongue, which is an indication of intoxication.
Okay, but that's not indicated in your report. Is that correct?
The thick tongue, yes, sir, it is.
It's not, but you did indicate that he had slurred speech.
Yep.
Now, you did not indicate that my client had red eyes. Is that correct?
Glassy eyes, not red.
Okay, so we're to assume that my client did not have red bloodshot eyes.
No, there was no red, just glassy.
Okay, so were my client's eyes red and bloodshot?
I believe they were glassy.
Judge, objection. The question would require the defendant to speculate. I mean, the trooper to speculate.
Overrule. I think he answered just glassy.
I'll proceed, Your Honor.
Okay.
Now, officer, my client got out of the vehicle. Is that correct?
Yes, sir.
Was he hostile toward you in any way?
No, sir.
Was he combative?
No, sir.
Was he able to get you all the information that you needed?
Yes, sir.
Okay, now you also don't indicate in your report any sort of sign of intoxication from my client. So is it fair to assume that he was not swaying while standing?
He was using his vehicle for balance, but that's why I conducted.
That's not indicated in your report. Is that indicated in your report, Trooper?
No, sir.
Okay, now would you agree with me if I stated that in your report, you do not indicate that when my client exits his vehicle, he shows any signs of intoxication, at least until it's time for the SFSTs? Is that correct?
That's correct.
Does he sway?
Not that I remember.
Does he struggle getting out of his vehicle?
I can't recall, sir.
Does he struggle getting you any of the information that you require of him? For example, a driver's license and
I believe he didn't struggle.
okay.
I wouldn't use the term struggle, no, sir.
Now, you had been trained in standardized field sobriety tests in 3 years. Is that you had about 3 years of experience administering standardized field sobriety tests at this point? Is that correct?
Yes, sir.
Okay. And you're stating that my client was unable to take the horizontal gauge nystagmus test. Is that correct?
Yes, sir.
And that's because he does not have equal tracking because essentially he is cross-eyed in one of his eyes. Is that correct?
Correct, sir.
Okay. And that's something that, would you agree, he has no control over?
Yes, sir.
Okay. Now, at the time of the arrest, do you recall if my client was overweight?
I wouldn't know the definition of overweight, sir.
Overweight, maybe, would you agree with me that he's a chubby guy, that he was a chubby guy at the time of the arrest?
I remember him being a tall
Objection,
man.
Judge. Relevant.
It's relevant, Your Honor. I'm getting somewhere.
All right, overrule.
And also, Trooper, you indicated that my client admitted to you that he had a messed up ankle, an injured leg. Is that correct?
Yes, sir.
And that's why you didn't give him the walk-in turn test. Is that correct?
Yes, sir.
However, you did give him the one stand. Is that correct?
Yes, sir. Yes, sir.
However, as you are aware, as certified peace officer in the state of Texas, if an injury is claimed, there are alternative standardized field sobriety tests to give someone. Is that correct?
Yes, sir.
And did my client have the opportunity to take any alternative standardized field sobriety tests?
No, sir.
However, you are aware that there are alternatives for people who do not qualify for the tests you would normally administer.
Yes, sir. There is alternative tests.
Knowing full well that you could have administered alternative tests.
I could have, sir, but by the time we finished the one leg stand, I believed it would be relevant.
It's a yes or no question. Your Honor, I'm going to object as non-responsive.
All right, sustain.
It's a yes or no question, Trooper.
What was the question again, Mr. Dillon?
That he was full aware that there were alternative tests that he could have given my client.
Right, he said yes.
And then that he nonetheless had my client take the 3 tests that knowing if an injury is claimed, there are alternative tests, Your Honor. And I kind of forgot what my last question was, Judge. So if I can just proceed, Your Honor.
All right, you may proceed, yeah.
Okay. So Trooper, would you agree with me that there were tests that you could have provided my client that you did not provide him?
Yes, sir.
And you actually had him take a test that is flawed because an injury was claimed?
No, sir.
So you disagree that if an injury is claimed, especially a leg injury, that the one leg stand even should not have been performed?
I disagree, sir.
So you think with a sprained ankle, he could have still taken that test?
Yes, sir, because the suspect at the time gets to choose which leg he wants to be planted. If his right ankle is the one that's sprained, that's why I advised him to use that one to be lifted 6 inches off the ground. Really,
but is it possible that even lifting an injured ankle can cause pain and unbalance?
For a sprain, sir, I mean, I'm not a doctor, but I do believe elevations actually help for a sprained ankle.
Could that injury have affected his performance on that test?
Not for the one leg stand, sir, no.
We do know that there was alternative tests that you could have given him.
Yes, sir.
Finally, officer, you've previously testified that my client admitted to having drank two 24-ounce Modelo beers at 4 p.m. and at 8 p.m. Is that correct?
That is what he stated, yes.
Okay. Did you ever ask him what time he stopped drinking?
No, sir.
Would that have been an important question in determining whether or not somebody was intoxicated?
Yes, sir. We could have.
How you didn't ask him that question, is that correct?
No, sir.
So you didn't ask him, or I'm correct?
I didn't ask him what time he stopped drinking.
Judge, at this time I passed the witness.
All right, Mr. Gwynn, any more questions? Any more questions, State?
Yes, Judge. Trooper, how was the traffic that night?
And that area was light, sir.
What, can you repeat that? I'm sorry, I didn't hear.
At that time, it was light, minimal traffic.
That's all the question I have for this witness, Judge.
Okay, the stop was on 11/2/2019. What time was it? More or
It
less?
was around 2:30 a.m.
2:30. I'm sorry, 2:30 a.m. a.m. There we go. Okay. Mr. Ortega, do you have any more questions?
No further questions on from the defense, Your Honor.
All right. And were you
We
going to
would
put
just
on your
reserve
client?
for argument.
Okay. Are you going to call any more witnesses yourself? Any witness?
No witnesses from the defense, Your Honor.
Okay. And State, is that it? And no other witnesses?
No other witnesses, Judge.
All right, Officer Trooper Diaz, thank you so much for your time. Your excuse, sir. Thank you for your service. Bye-bye.
Thank you, sir.
Thank you, Trooper.
Thank you.
Yeah, final argument briefly here, Mr. Ortega. I have a question.
Your Honor, respectfully on behalf of
Is there a video?
Yes, Judge. I'll
Okay.
submit it to your
Right.
report.
I'll view the video. Okay, Mr. Ortega, go ahead.
Your Honor, we would respectfully request on behalf of my client, Mr. Rodriguez, that our motion to suppress be granted for numerous reasons, Judge. Briefly, for three reasons. Briefly, the first part, Your Honor, is that the officer, though he testified to where he was patrolling and what area of the city and he was patrolling at that time, and what area, city, and state he was patrolling, he did not testify into what city, county, and state the actual stop occurred. So he did testify where he was working that day, but he never testified to where the stop occurred, Your Honor. Also, Judge, we do not believe that there was probable cause or reasonable suspicion to stop my client, as the only indication is that my client was allegedly failing to drive in a single lane. There's no indication he almost caused an accident. There's no indication that he was a danger to any other vehicles on the roadway, Judge. Finally, we do not believe that there was any probable cause to arrest my client for driving while intoxicated, because the officer's own testimony indicated that all he noticed was glassy eyes, a strong odor of alcohol emitting from his breath, and his alleged drive. There's no indication of any red bloodshot eyes, any swaying. The testimony indicates that he did not have any issues with my client, that my client did not show any signs of intoxication once he exited the vehicle, Judge. Finally, Your Honor, the standardized field sobriety tests are wrong. My client did not qualify for the horizontal nystagmus test and should not have taken the one leg stand and the walk and turn because he did claim to have an injury. The officer or the trooper did testify that there are alternative tests to give people when an injury is claimed. That officer knew of those tests at the time, however, did not give my client the opportunity to take those tests to further prove that he was not yet intoxicated, Your Honor. He just went off of the tests that were already flawed because those were the ones that he decided to give my client. However, those tests are flawed, Judge. For those reasons, Your Honor, and the two clues, Judge, the officer never testified that my client actually failed that last test, which he shouldn't have given him anyway because my client was injured. For those reasons, Your Honor, we would respectfully request that our motion to suppress be granted at this time.
All right, thank you, sir. State.
Yes, Judge. Judge, you should deny the motion to suppress because on the ground that defense counsel say that the trooper didn't state where the stop occurred, but he stated what he observed while patrolling in Elsa, in the city of Elsa, in Hidalgo County, in Texas, where the defendant caused a violation that gave him reasonable suspicion to pull the defendant over. And Judge, I mean, as you heard from the trooper, he said that night there was light traffic that night. I mean, as long as there's traffic, there's a reasonable chance that defendant, if he keeps swerving, he will hit someone. And as the video will show you, Judge, that the defendant was swerving that night. And for that reason, Judge, the state requests that you deny the motion to suppress, Judge.
All right, and because there's a video.
Respond in one sentence.
Yes, sir, yes.
How was your respond, Judge Jim, on counsel's own test?
I'm sorry, Mr.
I just wanted to
Tegon,
add that
Mr.
point.
Tegon, you were skipping. We didn't get to your last statement. What was it again?
My brief response was, Judge, just on the prosecutor's own testimony, the officer never occurred.
Okay, once again, you were skipping. I didn't get to hear the last part.
Is this better, Your Honor? I don't understand what's happening with me. Just that off the prosecutor's own testimony, the officer never testified as to where the stop occurred. I just wanted to make that last statement, Your Honor.
Okay, I think prosecutor said that on the night of 11/2, the officer must have been in the area because he observed this vehicle. So if he did observe it, I think that makes it pretty much clear that he was there. Is that what you meant, Mr. Nguyen?
Yes, Judge. It doesn't matter what the stop happened, but whether the violation occurred that gave reasonable suspicion. And the officer observed while patrolling in Elsa, the city of Elsa in Hidalgo County in Texas, Judge. He observed the violation occurred in
that state.
In the location.
And that's just one of our many arguments, Your Honor. No, that's not our only argument.
Okay. All right. Well, because there's a video involved, the court's going to take some time to look at the video, hopefully today or tomorrow. And so we'll take the matter under advisement and we'll issue a ruling real soon.